All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. Let all who have cause to plead draw near, give attention, you will be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning and welcome to the Florida Supreme Court. Our first case today is number 2023-1540, Geico versus Glasco.
May it please the court. I'm John Marino, and I'm appearing this morning with my partners Lindsay Trow and Max Gershinoff, and we represent Geico. Could I reserve 5 minutes for rebuttal, please? The Florida Motor Vehicle Repair Act uses the word customer 65 times. The word customer is a defined term under the Act. It's defined as the person who signs the written repair estimate or any other person whom the person who signs the written repair estimate designates on the written repair estimate as the person who may authorize repair work. So the legislature presumed two things in defining the term customer under the Act. One, that there would in fact be a written repair estimate, and two, that somebody would be signing that estimate. So this case deals with what to do when a windshield repair shop doesn't give an estimate to anybody, so nobody can sign one, as well as commits additional violations of the Act. The 11th Circuit has asked this court to answer two certified questions in these circumstances. Turning to the first question, which is can Geico bring a direct claim under the Act in these circumstances? Section 921(1) of the Repair Act gives a private right of action to any customer who is damaged by a violation of the Act. So Glasco just doesn't give an estimate to anybody, so nobody can sign one, and then there's no customer. That simply.
Well, let me ask you something about this estimate. Doesn't the basic provision here say that when the customer requests a motor vehicle repair shop to perform repair work on a motor vehicle, the cost of which repair work will exceed $100 to the customer? That's the kind of the operative language. That's what gets us off going down the pathway. Am I wrong?
No, that's correct, Your Honor.
Well, isn't it the case in these circumstances that the customer, just given the way that the insurance law is set up and the requirements that there be no deductible under these comprehensive policies, that the customer is going to pay nothing?
The customer is going to pay no deductible, Your Honor.
Well, pay nothing, right?
No deductible.
So there's no way that it's going to exceed $100 to the customer.
Well, that's not correct in this case, Your Honor. In this case, if you actually look at the assignment of benefits that they have these insureds sign, it specifically states, I further understand and agree that if my insurance company should ignore this directive to pay or otherwise fails to pay Glasco, Inc., all amounts due hereafter, I will directly pay Glasco, Inc.
So your position here is dependent upon an assumption that you are going to violate the law.
No, sir, Your Honor.
Your client's going to violate the law.
Well, not my client, no.
But by not paying, but the insurer by not paying what the insurer is required to pay.
Your Honor, I mean, insurance is not limitless. There are limits on insurance. It's true there's no deductible, but there are limits on insurance. And, they're not telling the insureds how much they're on the hook for. Because the assignment of benefits, and that's at docket 20, page 548 of the record, it specifically says they're keeping them on the hook for all amounts due hereafter, but they're not telling them how much those amounts due hereafter may be. I mean, their amounts, yeah, they're chasing Geico now, but they haven't recovered everything they want to recover on these invoices that they've sent.
So what would Geico do if the customer decided that they wanted to just pay the invoice and then submit a claim to Geico? Would Geico kind of interrogate the customer to say, well, were you actually legally required to pay this? And if the answer is no, because the notice wasn't given, would Geico then deny the claim?
Your Honor, if they submitted a claim, then Geico would pay to the limits of its liability.
Regardless of whether,
Well, no.
regardless of if the customer, let's assume that the statute wasn't complied with by
Sure.
Glasco, what would Geico do? And would they say, well, you didn't actually owe that, so we're not paying it?
I believe that's correct, Your Honor. If it came to Geico's attention that in fact the statute wasn't complied with, they didn't give the appropriate notices. They didn't give the estimate that's required. They didn't send an invoice. They're claiming that the customer is the insured. They didn't send an invoice to the insured. They gave them no notice at all. I mean, the statute's designed for transparency. That's what the whole statute centers around. But yes, Your Honor, we would not pay, or Geico would not be obligated to pay under the law if they knew that the services basically weren't lawful in the first instance.
So
Well, it's just hard, but again, a predicate here is injury to the customer. And I'm just struggling to see any injury that you can raise or that a customer would want to raise. There are no customer complaints about any of this. It's the insurer's complaint. It appears from what's been happening in the lower courts that the insurer decided they were going to lowball on these claims. They were going to pay less than the amount that was invoiced. And am I wrong in reaching the conclusion that every court that has considered whether the insurer paid enough when there was a dispute about it has decided that the insurer was not entitled to pay less, the lesser amount that they'd paid?
We've actually won some trials in the county courts, Your Honor. So not every court has made that determination. Only one case has actually gone to jury trial, and the jury verdict came back for Geico in that situation. Went on appeal. Well, the judge overturned the verdict, went on appeal, and the second DCA just reinstated the verdict. So you're right, Your Honor. We're losing the great majority of the cases, but we're winning some, and we won a jury trial. But the other point is, Your Honor, these cases aren't considering the Repair Act. In the county courts, they don't hear the Repair Act at all. They either strike their affirmative defense if you raise it, or they grant summary judgment. So nobody hears about the Repair Act. We weren't even allowed to raise the Repair Act in the case we tried to a jury.
Well, so you think that's been improperly stricken?
I do.
That's subject to appeal?
Well, some of them are on appeal now, Your Honor, and that's been stayed. There are, I don't know how many appeals, there are several appeals before the second DCA. They've stayed those cases pending this court's determination.
I guess my problem is more fundamental. Can we talk about just the text? I don't see a private right of action to anyone but a customer in the statute. And I don't see how Geico is a customer. Help me understand those brute realities of the text.
Well, remember, Your Honor, the customer is a defined term.
Yes.
And it's fact specific.
Well,
right?
I don't think.
It's who signs.
Is Geico's position, has Geico's position ever been, and is it here today, that it is a customer?
I think under these circumstances, we should be considered
Under
a
which
customer.
circumstances?
The circumstances where the statute wasn't complied with. Because remember, we have no customer.
Okay.
Nobody signed a
So
written repair.
your argument is whenever the cause of action only lies when the statute hasn't been complied with. It is a cause of action for violations of the statute.
Correct.
Okay. So your argument sort of consumes itself beginning with its own tail. The cause of action only exists when there's been a violation of the statute, and those are the circumstances you're saying where we should ignore the word customer and just substitute payor for customer. Unfortunately, that's not what the text says, and your briefing, if I may say so, doesn't really square up to just the brute reality of the text. It instead asks us to consider legislative intent. It asks us to consider all sorts of phantasmagorical considerations about what might be lurking behind the text. But I have not seen Geico square up to the actual words of the statute and say, we are a customer or we are not, and I'm giving you an opportunity to do that here.
We should be considered a customer in these circumstances because there's not a
In the
customer.
circumstances wherever there is a cause of action.
Not just wherever there is a cause of action, but under these circumstances where no customer exists, because the insured's not a customer either. Nobody's a customer under the plain text of the statute, because the customer is the person who signs the written repair estimate or their designee. So who were their designees?
So if it's not covered by the statute, we just make it up?
No, I'm not asking you to make it up, Your Honor.
Well, I think you are. It's hard for me to see how what you're doing is anything other than asking us to fill in some gap that is not covered by the statute. I mean, I don't understand how to decode your argument in any other way. And have you read our cases recently when we talk about the supremacy of the text? Your briefing doesn't seem to indicate that.
We have read the cases, Your Honor, and supremacy of the text. We realize you start with supremacy of the text, but you don't take it to the degree where the statute becomes meaningless.
I think the issue with your interpretive argument, you've presented this entire argument on the 11th Circuit and here is a matter of interpretation. And it sounds like what you're saying is like there's a right without a remedy, and people make those arguments, but it's not a matter of interpretation. That's a completely different challenge that's based on the constitutionality of a statute. And so why should we contort a statutory analysis to fit an argument that you haven't made?
Well, Your Honor, you know, the district court actually called this a hole in the statute, and they went beyond the plain text. They construed it narrowly, and they decided that in these circumstances, they basically filled in a customer, right? They said it can only be the insured. I don't think that's correct, but that's what the district court did. The district court recognized that, you know, if we reach the conclusion that we have no customer, then we have no repair act.
Go on. It seems odd that you're saying that the role of this court is to fill in holes in statutes rather than interpret text as it's written.
Well, I think you do interpret text as it's written, but you don't take that to the extreme that there's in fact no statute. You basically written off the statute.
So your argument kind of turns on the absurdity doctrine.
It does. Well, the absurdity doctrine, yes, and ambiguity, because it's not the definition of customer that makes this statute ambiguous. It's the lack of any guidance of what happens when they violate the Repair Act. There is no written estimate. So you don't have a customer. And the statute doesn't tell us what to do in those circumstances, and that's what the district court did.
It would seem to me, though, to sort of build on what this colloquy with Justice Sasso you're having. It sounds like these are great arguments for across the street. I don't understand why you're making these arguments here. If there's a hole in the statute and you say that this is some sort of like a null set where there is no customer in this weird circumstance of windshield repair because of the way the market has played itself out, sounds like you've got a legislative issue. Don't you agree?
It is a
Hire
legislative
lobbyists.
issue.
Go
Your
across
Honor,
the street.
It is a legislative issue, and the legislature has actually dealt with these issues going forward. The legislature recently took away the assignment of benefits. So they basically cut the glass industry off at the knees. They took away the assignment of benefits, I think it was as of May of 2023. So they recognized the issue, and they dealt with it going forward. But there's still some backlog here with the cases that are still pending. And basically, what we'd be doing is allowing unlawful services to be compensated.
Let me ask you about that, because that seems like, to me, that's an easier sort of textual argument that also I think is a problem for you, which is it seems like all this law sort of goes back to this Osteen case from '86.
Correct.
Where it was just kind of assumed that where the notice requirements aren't complied with, that essentially that the customer owes nothing. Mm-hmm. And that's definitely, I don't see that indicated in the text. You know, the civil remedy talks about where the customer is injured. We now have the sub 7 that's been added that basically instructs the enforcing government authority that where in fact the customer, you know, was on notice of what was going on and a legitimate service was provided, the company gets credit for that. So if we think that that whole premise is wrong, that, you know, that the customer owes nothing in those circumstances, what does that do to your case? I mean, I think for question number 2,
correct,
it would basically, you'd lose on that, right?
If that was your decision, yes.
Yeah, and so,
But
but I don't want to put words in your mouth. I mean, what's your take on that?
I think two issues, Your Honor. One, the statute, it doesn't contain an express voiding penalty. It doesn't say you can't get paid if this happens, but it does say you can't start work until you've satisfied the requirement to give the written disclosure and to give the estimate. The statute specifically says,
but we're still just back at the same point of if the statute isn't complied with, what's the remedy? It seems like what the remedial part of the statute says is if the customer can prove that they were injured by it, then they get whatever the remedies are. But it just seems like this whole area has been premised on just kind of a mistake at the beginning back in Osteen.
well, I don't know that I characterize that as a mistake. I mean, every court that's considered the issue has said, starting with Osteen.
Essentially just citing that Osteen itself, you have to admit, there's no reasoning in there. It just kind of assumes that that's the remedy.
It says it's a remedial statute, and to effectuate its purposes, we're not going to allow payment. And that's what the line of cases have followed. But the legislature is deemed to be aware of the interpretations of the statute. And like Your Honor pointed out, they amended the statute to add Section 921.7, right? Section 921.7 is an exception, like Your Honor said. Under Section 921.7 of the statute, you can get paid under limited circumstances. 4 things. 1, the work was actually approved. 2, the cost was actually approved, orally or in writing. 3, the customer benefited. And 4, the work was done satisfactorily. So why would the legislature put in an exception to allow payment under certain circumstances if the legislature intended that you couldn't get paid, if the legislature intended that you could get paid even if you violated the statute? Why would the legislature put in an exception under those circumstances?
Well, why would the legislature say you have to be injured?
I
So
think,
how do you explain that?
I think Geico is injured. They've been sent bills for things that are not payable under the Repair Act.
Well, how was the insured injured?
The insured is injured because they're still on the hook, as I said, for amounts that were never disclosed to them. Who knows what would have happened, Your Honor, if they said, "Here's a written estimate. Here's what we're going to charge you." I mean, that's what the Act is designed for, right? Transparency. So who knows what would have happened if they said, "We're going to charge you $1,000 for this windshield." Well, maybe the insured says, "Well, that sounds like a lot for a windshield, and I'm not sure my policy covers that amount. Maybe I'll call up my insurance company and see whether this will be covered. Or maybe I don't want to make a claim that large against my insurance policy, so I'm going to go down the road and see whether I can get it for less."
I mean, the problem, though, is that, this is a prophylactic statute. If every single piece of material information was disclosed orally and there was a complete knowledge by the customer and they could go through all this thought process that you're talking about, there would still be a violation and you would still be saying that the customer owes nothing and therefore you owe nothing.
Well, if it had been disclosed orally, it may be subject to the quantum merit exception that the legislature wrote in.
But in some ways, all of these factual things sort of it kind of confirms the wisdom of why it really does need to be the customer. You either need to be standing in the shoes of the customer,
and I think we are,
which you've throughout this entire litigation you haven't. You've said we have no subrogation, whatever. So this is you guys coming in on your own.
Well, I think we should.
So you're basically trying to assert all these things that really only the customer is in a position to assert.
But it still comes back, Your Honor, to under these facts, there is no customer, and the courts are just assuming, it must be the insured.
I don't know that
nobody signed a written request.
I don't know that we need to agree that defined term, obviously in the notice context it makes sense, but there's all kinds of stuff in here that says, you can't put a false thing on the credit card or whatever. I think if the Department of Agriculture and Consumer Services wanted to, go after a company for doing that, I don't know that the company would be able to say, well, actually that doesn't protect a customer, or it only protects someone who signed, there's no sign, so therefore you can put these charges on some. I think it's arguable whether we need to be that literal about the defined term, but it still doesn't get you to be the customer.
If that's what the court's going to determine, I still believe we should be able to assert an affirmative defense. You're right, Your Honor, we haven't raised subrogation. That's not on the table. But that doesn't mean we don't stand in the shoes of our insured. Because if our insured doesn't owe anything, then how does Geico owe anything? I mean, if I have an insurance policy and I don't owe anything under the insurance policy, my insurer doesn't have to pay.
So if we disagree with you on the premise that the customer wouldn't owe anything absent injury, then we can just answer, I guess, no to both of these questions and be done with it.
Well, I don't believe you should answer no to these questions.
But we
and be
could.
done with-
I mean, that would
you
be the
could.
correct. That would be the correct answer. If the premise is that it's essentially your remedy is you have to show an injury and et cetera, then at least the answer to question 2 would be no.
If you have to show if you have to be a customer and you're saying we're not a customer, then the answer to question 1
Well, even
would
if
be
you
no.
were a customer, the question I think assumes that it's just sort of per se. If I show these 5 specific violations and a claim is submitted, whether it's by a customer or by the insurance company, or whoever, the invoice is sent either to a customer or to the insurance company, that essentially whoever the receiving entity is, they owe nothing. That's your argument, right? Is that once you show that the notice wasn't compliant
It is.
with-
Once there are material violations of the Repair Act, there's nothing owed under the law. The law doesn't permit this work to be done before there's a written estimate and before the written disclosure is satisfied. The law doesn't permit it.
Okay, you can take 30 seconds and then we'll give you 3 minutes of rebuttal.
Okay. Well, I'll just sit for my rebuttal time.
Good morning, Your Honor. May it please the court, counsel. I'm Michael Lorado. I represent the appellees in this particular case. As the court has indicated, Geico's purposivistic interpretation of this statute is to be completely rejected based on this court's precedent. The questions certified by the 11th Circuit are easily answerable by turning straight to the plain language of the text, and the plain language of this text, taken as a whole, will the words enacted by the legislature tell us what the legislature's intent was. We have to focus on those words, and that requires that this court answer both of these certified questions in the negative. Let me start first with whether Geico is a customer.
What if we agree with you that Geico's not, but that there is no customer for the purposes of the statute in this fact pattern?
I don't think you can do that reading the text of this particular statute. Because
Help me understand how that's true if nobody signs a work order.
Well, because the statute in and of itself contemplates circumstances by its plain text where a customer is not to sign a written estimate. So there are circumstances by its plain text, as Justice Kennedy mentioned, that in Section 559.905, a written estimate signed by the customer with the required disclosures is only required when there will be charges to the customer in excess of $100.
That's right, but now let's answer the argument that your opponent makes, which is, of course, those charges are there. They're perhaps baked into what they're paying for comprehensive coverage, and just because they're not presented with a deductible doesn't mean there isn't a charge. There is a charge, and the customer just may not have transparency into what it is you're seeking on the back end. You're not arguing that there's no charge, right? Glasco gets paid.
Right. I think, correct. I think that goes to the second question, right, of whether there's a voiding penalty or whether the customer would still be on the hook. Okay? So the answer to that question is, again, in the Repair Act itself, right? The language of the Repair Act is clear. If, in this case, it's undisputed that there was a written estimate which was signed that said 0 to the customer, and the customer also waived the right to a written estimate. So let's assume that then Glasco goes and submits a bill to Geico, Geico doesn't pay it, and Glasco then pursues, asserts a lien, doesn't return the car, that hasn't happened here in this case, or sues on the repair invoice. The customer then would be able to say, under 559.905, I didn't get the right estimate. I was estimated at 0 charges. You are now wanting to charge me $1,000. The penalty provided by the statute is not a voiding penalty. The penalty provided specifically in 559.909 says that where the customer doesn't obtain this written estimate, where the repair shop doesn't do it, their liability is limited to $10 or 10%, not to exceed $50. So even in the case where a customer were not to get a written estimate, the penalty provided by the plain text of the Repair Act is to limit the repair shop's charges to $50. So the question becomes, that's the statutory penalty when a repair shop doesn't comply with a written estimate to the customer.
Wouldn't you then be arguing waiver, though? Wouldn't you be saying to the customer you waived your rights here?
Under the facts of this particular case, right? Under the facts of this particular case, the customer has to do that waiver in writing, and I believe that as a matter of record, the actual invoices, and again, the plain language of the Repair Act, permits a customer to waive the written estimate in writing. And I believe that all the written, 0 to the customer written estimates in this particular case also contain a written waiver of a written estimate by the customer. So the customer is not only saying, look, you can repair my car, you can bill Geico, you're going to charge me nothing. I waive a written estimate under the particular statute. And
but what would you guys charge in the scenario where, for whatever reason, the insurance company didn't pay, and you pull out the assignment of benefits thing, and it says that the customer is still on the hook? I mean, what would you charge them? You wouldn't charge them $50, would you?
They would be limited by law to that.
No, but what would you say that what bill, wouldn't you send them the same bill that you sent the insurance company?
Correct, assuming that Geico denied the claim,
right,
and didn't pay it, the customer would get the same exact bill that.
So it seems like, I mean, your position, the more kind of weird the more kind of absurd, I hate the word absurd and the absurdity canon and all that, but the more kind of irrational you make the statutory scheme sound by getting in all these kind of counterfactual hypotheticals. I mean, what's your position on this whole Osteen thing, and whether at the end of the day that is the problem? Because it seems like it really would be an irrational statute in a crazy world if this, under the same fact pattern, if Glasco sends a bill to the customer owes nothing, and if they send the exact same bill to the insurance company has to pay 100% of the bill. Like no legislature with any foresight would ever make that the rule. Do you agree with me on that?
I do agree with you on that. I don't agree with you with this case. This case presents to us in a procedural posture where we are assuming, based on the 11th Circuit certified question, that there are in fact violations. As a matter of record, though.
No, but let's just take the case as we've found it. You know, it's limited to these 5, violations, and they've essentially teed up. It's almost like an advisory opinion type thing. You know, assuming the violations have been, that's what's on the table. Under all this DCA precedent, those violations would be enough for the customer to owe nothing, right?
Incorrect.
Okay, why is that incorrect?
Well, first of all, the statute which you mentioned, 559.920 Section 7.
Right, none of which the DCA precedent considers. That's what I'm saying. I think the DCA precedent is all wrong, but so just accept the question was under the DCA precedent.
There's Lieberman's and KT Cars.
Which says what?
Yeah, Lieberman's the first case. The repair shop prepared no written estimate at all, and instead relied on an estimate which the insurance company was going to pay. So as it related to the customer, the Lieberman's is important for 2 points, because it establishes that the distinction between the insurer and the customer. So in Lieberman's, there was no repair estimate at all, so a complete violation as it relates to the customer. The insurer had separately prepared an estimate that it was going to pay. The customer attempted to collect, I guess, the insurance benefits that were owed to the repair shop for the repair, and asserted that I didn't get a written estimate, and so therefore I can keep the insurance money that was paid. So there, Lieberman said that there was substantial compliance with the statute because the customer understood the transaction, the customer understood what was happening, understood that the insurer would pay, and therefore the repair shop in that case could enforce its lien and repair and recover on its lien in quantum meruit. That's the first case that says where a repair shop is kind of where the customer kind of understands the transaction, approves it, agrees to it, even if there is no technical compliance or no written estimate at all, that the repair shop can still recover on their invoice. The second case is KT Cars. The KT Cars case, there was a handwritten note. So there was some written estimate. It was incomplete, and it was very basic. It certainly didn't comply with all the elements that are required by the repair shop. There again, the court allowed the repair shop to again enforce its lien in quantum meruit and therefore recover even in the face of violations on its lien. So that's an important distinction in this case, right? Because there's two sections. There's the lien provisions of this statute, and there's the remedy provisions, as you've said. So under the lien provisions, a repair shop is specifically, under the plain text of the statute, entitled to enforce its lien if it's in substantial compliance. So that's text-based evidence as it relates to the lien statute that there is no voiding penalty in this statute, because even as it relates to a lien, they can enforce it, and the cases hold that you can enforce it in the event of substantial compliance. Here the legislature used the term substantial compliance. That doesn't mean technical compliance. That doesn't mean anything like that. And I would even suggest that Osteen falls in line with that. Because the important considerations under the statute is that the customer understood what was going on, received a beneficial repair, knew and approved of it, and when that happens, both the statute and the case authority clearly say that the repair shop should be able to recover. In terms of whether Geico is a customer or not, the first question, again, the text is very clear. The legislature has defined customer to mean certain things, and Geico clearly is not. I would note that they have admitted both before the 11th Circuit and in their briefs that they are not a customer as it's defined.
What do you make of their argument that you're not a repair shop?
We are a licensed repair shop, and that's all, a licensed and registered repair shop. And if you read the plain text of the Repair Act itself, we certainly qualify as what would be the definition of a repair shop. Their argument that Glasco is not a repair shop hinges on their flawed argument, again, misreading the...
Well, it hinges on your business model a little bit in that you're using independent contractors who may in turn qualify as repair shops under the statute. Their argument, as I understand it, is more that you're like a broker.
Understood that that's their argument. Here, as it relates to interpretation of this particular statute, the statute doesn't have a blanket prohibition against the use of subcontractors, and it has no prohibition against the use of independent contractors. I don't believe that's really an issue here in this particular case, because it's not developed on the record about whether independent contractors or subcontractors, as that term is meant under this particular statute. But even assuming it is, even assuming that independent contractors and subcontractors are the same under the statutory language for purposes of my argument here today. So we assume that. There is no blanket prohibition of a repair shop using either an independent contractor or a subcontractor, and the plain text of the statute permits it as long as the customer knows about it and approves of it. Here on this record, in this case, in every one of these with the initial paperwork they got, there was, as reported in the 11th Circuit opinion, every customer received a document that says, I authorize sublet work to be done here. And so it's not a violation of the Repair Act. And again, I understand that I come to this case in the posture where we are assuming, for purposes of this question, that there were violations. But on the record, there really weren't violations. For instance, a subcontractor violation can only occur if the insured did not have notice of it. But yet, as the 11th Circuit noted in its opinion, every insured in its initial paperwork specifically authorized the use of sublet work. So, therefore, subcontractors. And so that wouldn't be a violation. You know, it is conceded in terms of violation that the initial paperwork, the zero to the customer paperwork, which was signed, didn't have an odometer reading on it. But again, I think that turns back to the requirement that even if Geico is the customer, there would have to be, in order for there to be a standalone cause of action, there would have to be an injury resulting from that. That also, the statute is plain. It's a customer who's injured by a violation of this part. Another important point, Justice, on the independent subcontractor issue. There is nothing in this record that any customer or Geico itself was injured by the difference in the work that was performed by either, if it was performed by a Glasco W-2 employer, W-2 employee, or an independent contractor. What would be the difference in price? What was the difference in the quality of work? There's nothing. In fact, on this particular record, all the repairs were satisfactorily performed. And so what Geico is attempting to do is kind of turn this statute on its head by its interpretation, right? All of the customers were satisfied, all of the work was satisfactorily performed, and yet it doesn't want to pay. That would be against Section 7, right? And in essence, Geico wants to call itself not only a customer, but it wants to call itself the enforcing authority, right?
I mean, the whole thing, though, I mean, the legislature created a moral hazard by giving people the impression that this is quote-unquote free. The whole logic of the statute is that it's going to matter to people what things cost, and there may be a negotiation, et cetera, et cetera. So I mean, we're applying it in a situation that doesn't really fit sort of all the prophylactic stuff and everything that's going on. I mean, even the fact that that there's a limit on the charges that's kind of embedded in the notice thing. I mean, that is a problem with the statute, that you don't, essentially when you don't do these disclosures, then there's no cap on, you know, the $50 or 10% thing or whatever goes away, right?
Correct. I would say that that's again a legislative.
I mean, that's not our problem,
right?
But
It's not this court's problem and not this court's issue, and that's probably the most important part of this particular case. Is this is really an insurance claim transaction which is regulated by other statutes, right? Not a Repair Act transaction. I mean, I would understand here if Geico owned the vehicle and Geico requested it, but ultimately this is an insurance claims transaction which is governed by another policy of insurance and governed by the insurance code. And the legislature kind of knew that, right? And we know that they knew that. As it relates to your Osteen case, I think the legislature reacted to Osteen in 1993 when it added that particular section.
yeah, the DCAs didn't notice apparently.
Right. Well, all the cases are, you know, Osteen, Safari, Perez Perigo, all those cases cited by Geico 1616.
The lien cases, I grant you, but people are continuing to rely on when it's just a pure, when you're outside the lien context, and it's just a pure issue of does the customer owe anything, it seems like they still believe, or they do believe, that the customer owes nothing. And that's why I think the 11th Circuit considers this a tough case. If it weren't for that anomaly, I don't know that we would be getting a certified question, and that they're, you know, because it really doesn't make sense. Yeah. But the answer to that is to say that that premise is wrong, I think. But
I think that all the questions presented here can be answered clearly by turning to the plain text. The definition of customer is plainly defined. It's referred to throughout the text. Geico doesn't qualify for that. There's no basis to go into intent or anything like that. The statute even understands that there will be circumstances where an insurance company will pay. It specifically says that, but it still doesn't equate them with the customer. plain language. There was, again, the 2023 amendments addressing these issues, which this kind of a crisis which is raised in their brief, or the issues which Geico alleges, and yet the legislature still didn't change the definition of customer. Knowing everything that was going on, they instead chose to change certain insurance statutes. They repealed 627.428, the attorney's fee statute, and they added a provision in the assignments that prohibits assignments for these type of insurance claims. But yet they didn't change the Florida Motor Vehicle Act. That simply tells us that this Florida Motor Vehicle Act doesn't apply to insurance companies, and insurance companies are not customers contemplated. As for the voiding penalty, we begin and end with the plain text there. There is no voiding penalty expressly on the text. End of analysis. The legislature, in various instances, knows exactly how to penalize someone who is non-compliant with a regulatory statute. They did it in the healthcare context, they did it in the PIP context, they did it in various other contexts, and they said that if you violate this statute and you submit a bill to an insurance company, that is non-compensable, voidable, and various other language. And so the legislature didn't do that here. This court's precedent says that the legislature, if it doesn't say that, there is no voiding penalty. Again, we can turn to the clear language of the statute. Again, I've referenced other provisions of this statute where even where there is a violation throughout various provisions of this statute, it's not that the repair shop recovers nothing. The repair shop may be awarded reasonable repairs. They can still get $50 from the customer. That's not a voiding penalty, and it can't be reconciled with the idea. And then even in enforcement of the lien provisions, the legislature has intended that if there is a violation of the Repair Act, but yet substantial compliance, as we see in Lieberman's and KT cars, even the repair shop can still enforce the lien, which is an entirely different remedy there.
Sir, you can finish up.
Great. Thank you, Your Honor. We would request, the plain text requires that these two certified questions be answered in the negative. Thank you.
Just a couple of points. The written waiver, there is no written waiver on these work orders. If you look at it's at docket 20, page 546, it does not have the language that counsel was referring to that says check a box and you waive the estimate. It's not on the work orders. That language appears nowhere in the record. Lieberman and KT Carr, as my friend stated, found substantial compliance. One case, there was a handwritten note, had the cost on it, customer agreed, they signed off on it, and the court said, okay, substantial compliance. The other case, the insured actually took an estimate prepared by his insurance company to the body shop, and the body shop agreed to make the repairs based on that estimate. That court said substantial compliance. In this case, the cost was never disclosed. There was no substantial compliance in this case. Those two cases don't change the rulings of the prior cases that basically say you can't recover if there's a Repair Act violation. As to Section 909, Section 909 doesn't say okay, you can get paid a little bit. It says it shall be unlawful for a motor vehicle repair shop to charge more than the written estimate plus $10 or 10%. It says it's unlawful. It doesn't allow payment when there's been no written estimate. It says it's unlawful to charge more than that. And what did they do? They charged far more than zero. Because if their written estimate is zero, they violated the law. Because that section says it shall be unlawful. Section 909.3. So, this isn't a situation where they charged $10 more than zero. They charged, I don't know what it is, $800, $900. They charged a lot more than zero and a lot more than $10. Section 559, 559.909.3 says that is unlawful. How can they recover for unlawful charges? Because that's what they're saying. They're saying, well, this work order is kind of the estimate and has zero on it. Well, if it has zero on it, they can't recover more than $10. It's unlawful to bill more than $10. And that's what they're doing. It's an unlawful charge under the Repair Act. We would request that both questions be answered in the affirmative. Thank you.
Thank you very much. All right, our next case is case number 2023-0432, Mitchell versus Race.
Good morning, Your Honors. Just for the record, I'm going to be arguing 10 minutes, and I'm ceding 7 minutes of my time to the State of Florida Attorney Generals and reserving 3 minutes for rebuttal. So, good morning. My name is James Steppen. I represent the petitioner in this case, William Mitchell. My client requests this court to reverse the decision of the 4th District Court of Appeal in Race versus Mitchell and hold that there is personal jurisdiction over the respondent, David Race, for 27 undeniable violations of the Florida Security of Communications.
Why doesn't your complaint allege the existence of jurisdiction under 481936, causing injury to persons or property within this state arising out of an act or omission by the defendant? You plead only that jurisdiction flows from 48193-2, committing a tortious act within the state. Can you help me understand why, I've looked at both the original and the operative complaint here, why you didn't just allege that the 27 phone calls caused injury in the state? Wouldn't that have settled everything?
That would have settled everything, and I guess if given the opportunity to amend, we can go ahead and do that. The primary reason at the time, though, Your Honor, was the existence of the France v. France case, which had already determined, I know we're now here reviewing to determine whether or not France was properly decided, but when we were pleading this, France was the most recent statement that had come out, and it said it's now 1A2, but it used to be 1B of the long-arm statute, said, that's it. The interceptions occurred here in Florida, and that's all you need. So that's really where we were going.
You would have said then that the tortious act was complete upon upon the speaking in Florida of the words that were intercepted. The tortious act was complete in the state under France v. France. That's basically your argument.
Yes, or that it occurred. I mean, the case law, particularly France, but I think more importantly, State versus Mozo, which we cited in our briefs, has determined that interceptions occur where the person's speaking. So my client, and by the way, it's undisputed that Mr. Mitchell was in Florida for all of the 27 phone calls.
Well, yes, but also the operative complaint doesn't allege that Mr. Race knew that.
The operative complaint doesn't allege that, but Mr. Race admitted in response to requests for admissions that he knew that my client was a Florida resident.
But he also specifically denied that he knew he was in Florida in the request for admissions, right?
He did, but it isn't necessarily, well, he hedged his bet a little bit. He denied that he knew that my client was in Florida when the calls occurred, but he did say that he knew my client was a Florida resident. It's no secret my client was a Florida resident. He's somewhat of a, dare I say the word, use the word celebrity in the video gaming industry, and so is Mr. Race, or at least he's trying to be.
Counsel, could you speak up a little bit? I'm having a little trouble hearing you.
Oh, sorry, Your Honor. I'm getting over a head cold, so I apologize for that. But basically, the gist of it is that State v. Mozo says that the interception occurred where my client was physically located at the time, which was in Florida. And there's really no reason to overturn that. That case is nearly 30 years old. It involves a statutory interpretation. It interpreted the language of the Florida Security of Communications Act, specifically the definition of oral communication. I would note that the state of Florida Attorney General's is supporting my client's position in this case.
Can I ask you about that, though? The Mozo thing, it cited a federal case that talked about the federal cases seem to arise in the connection where law enforcement is kind of a third party that's intercepting the call. And those cases are all premised on the idea that when law enforcement does it, that they're obtaining the call kind of where they're sort of redirecting. There's this kind of seminal case from the Second Circuit Court of Appeals up in Manhattan where it says, you're obtaining it / redirecting it from where the call is made. I don't know that analysis, which our court in Mozo didn't seem to really, it kind of miscited, to be honest with you, the 11th Circuit case. I don't know that when it's two people who are actually intended to be the parties to the call, that there, in that case, there's no redirection of the call in this case, by the recorder, by the, the person who's out of state. So I'm not really sure that, Mozo might make sense in the law enforcement kind of third party context, but I don't know that makes sense in this context. Can you address that?
Well, certainly, yeah. Mozo is interpreting Florida statutes, and I know this is an argument that Mr. Race made. There's really nothing, there's no reason that the language, or particularly the statutory definitions of, say, intercept or oral communication, wire communication, oral transfer, et cetera, should be determined differently in the context of an evidence suppression case, which was Mozo.
Well, but the statute, the language itself doesn't tell you anything about how you're supposed to figure out this kind of question. And when Mozo, kind of without any kind of analysis or apparent thought about how this applied, doesn't purport to be doing any textual analysis, they just say, see U.S. v. Nelson or whatever the case was. And U.S. v. Nelson is based on a specific set of facts about how the call was quote unquote intercepted. I don't know that we should just kind of mindlessly accept that.
Well, that's correct. I don't think this court should really mindlessly accept anything. But I would note, I guess as a 10,000 satellite foot view, nobody's asking this court to overrule Mozo. Even Mr. Race isn't taking that position either. We know Mozo, and my client knows Mozo because it's been around for a while, and we do think it decides the opinion or the outcome. But Mozo was, getting back to your issue about textualism, it interpreted the definition of oral communication, which is right there in the Florida statutes, and hasn't changed since 1997, really hasn't changed since 1974. And it kind of makes sense. It says oral communication means any oral communication uttered by a person exhibiting an expectation that such communication is not subject to interception under circumstances justifying such expectation, and does not mean any public communication uttered at a public meeting or any electronic communication. I know that's somewhat long-winded, but the operative language is uttered by a person. How do you utter something in any place except where you actually are? In other words, how can my client, Mr. Mitchell, have uttered anything?
But 48 focuses on the actions of the defendant.
Correct.
So I understand that there's a sense in which this is some murky thing about where is the conversation occurring and everything. But if the whole point of all this personal jurisdiction stuff is to focus on what the defendant is doing and the connection between what the defendant does and the form, everything the defendant did, the recording, the speaking, it was all in Ohio. In what state was he in?
Ohio. Yeah. That is correct. He was physically located in Ohio, according to his affidavit. If I can take 1 second, Justice Sasser, you raised a point about whether or not the defendant knew my client was in Florida. He did subsequently post on Facebook that he went to justia.com and copied Florida statutes for Chapter 934 and copied it on there and said, it is illegal in Florida to record a phone call unless all parties give consent. I'm paraphrasing.
I have questions about that as well, but I think if you could answer the Chief's question, then.
All right. The answer is yes. He was located in Ohio at the time, but for the purposes of committing a tort in Florida under the long-arm statute, if an intercept, and there's no reason to depart from Mozo in this particular instance, since intercept means that he intercepted the call. Let's write that. Since the law is such that where my client spoke, means that the call was intercepted in Florida. In other words, under Mozo and under France and under the definitions of oral communication and other definitions in the statutes, basically Race intercepted the calls in Florida. It was enough to commit a tortious act in Florida. It is enough to state that the tort as alleged occurred in Florida, which is really all you need for 1B jurisdiction, or 1A2, excuse me. So,
on the due process issue, how should we think about this case when I think it'd be fair to say there's at least a factual dispute over whether he knew, and if we're viewing the issue through the lens of the defendant's relationship, the defendant reaching out to the forum state, there wasn't an evidentiary hearing below, as there typically is in personal jurisdiction cases. And so how do we address the due process issue when there's disputed issues of facts? From a legal standpoint, the analysis can turn on whether or not he knew that he was calling somebody who was located in Florida, and there was no resolution of the factual disputes in the trial court.
The short answer is remand. I mean, we can have a Venetian salami hearing. Basically, if I can, it's not really on the record, but I can give it back. I can give it background as to why there wasn't. We had this was initially assigned to one judge. That judge retired. We had a new judge. This was COVID. We had a case management conference. The trial judge said, we actually had a pending motion to compel jurisdictional discovery at the time. The trial judge says, no, we don't need that. Let's go forward. We're having a hearing in a week. I got everything briefed, and we did it. It was over Zoom. It was back in 2022. But if the court thinks that there are factual disputes, I mean, frankly, I could add more to the record anyway, more additional context, because I'm very certain that there are additional electronic contacts. So to answer your question, answer Your Honor's question, remand it back to the trial judge.
Do you think we can resolve it in favor of your client without remanding back?
Yes, you can. My client, the 1B issue, as I said, we believe is settled by Mozo and the statutes and the other case law. But there are sufficient context, either under the Calder test or specifically under minimum context. I mean, we have 27 undeniable phone calls. He's recorded calls with other Florida residents. There is a social media and internet and media campaign, all of which he's been directed at my client, which is frankly ongoing. I don't know if I'm allowed to say this. It's outside the record. I checked his prove all.
Don't you think we need something then indicating that the person who's recording the calls knows that the person is in Florida? I mean, I like the idea of us walking around the country with like this special bubble protection because we're Floridians, but I'm not sure that's how the law works.
And that's correct. I mean, but my client was in Florida, and he is entitled to the protection of Florida law while he's here. I mean, he never left Florida. We put the cell phone records into evidence. And if you look at the cell phone tower there, it's heavily redacted. It's the part of the record that's heavily redacted. The cell phone towers are all in Broward, and maybe one or two of them was in Miami-Dade. My client's a Broward resident. He's been living here for 40, 50 years.
You mentioned that perhaps that there was sufficient jurisdiction based on traditional minimum contacts.
Yes, sir.
Based on the fact that there were 27 phone calls. Okay, let me ask you this hypothetically. What if there was just one phone call?
What if there was just one phone call?
Yeah. Just one phone call that lasted 30 seconds.
Well, that's 30 seconds.
It was taped and then played someplace else.
There would still be minimum contact. I'm sorry for speaking over you, Your Honor. There would still be minimum contacts given the other additional electronic communications by Mr. Race. If your question is it one phone call of just one phone call only of Mr. Mitchell under the context of this case?
Let's say I got a call from Ohio, and somehow it got through my office, and someone wants to know how come I ruled one way or the other. I guarantee you that call will take about 2 seconds. But nevertheless, it's taped, and all of a sudden I'm hearing myself all over the place saying, I can't answer that question. Is that one call sufficient for me to bring this person into Florida?
If there are other minimum contacts, yes. If there aren't, then no. If this was in a vacuum and was a one call of his 2 seconds and Mr. Race had no other contacts in Florida, then excuse me, then the minimum contacts or the due process test wouldn't be met, because that's which, by the way, is the instance in every case when we have a constitutional question. I mean, that's why the court said way back in Venetian Salami, you can't necessarily have a bright line rule for every case because it's fact specific and facts dependent. So in the situation that you just mentioned, Justice Labarga, if there was only one call but no other contacts beyond that, there could not be, it could be possible that there is not jurisdiction.
So actually, before you sit down, I want to make sure we're clear on that point. Mm-hmm. So you think that you could actually commit a tort in Florida under this hypothetical, i.e. by recording the 20-second phone call when you're not, you're in Ohio, and still, we would still have to do the due process inquiry? Because is there any case where a court has said that even if we stipulate that the tort occurred in the state, when I'm not saying that I agree with that, but let's just take that as a premise, that you still would have to go through this other, that isn't enough?
There's no case, at least that I've located, in which there is a stipulation that the long-arm statute was met and that the only issue was minimum contacts for the Florida Security of Communications Act. There aren't that many cases.
But just in general, I mean, I'm kind of surprised to hear you saying that we could think that the tort occurred in Florida and that there still could be a question of whether due process was met. Well, I mean, I understand going through all that when the tort wasn't occurred in Florida and you're talking about effects and contacts and whatever, but.
Well, it's just because it's a hypothetical, Your Honor, and perhaps I didn't answer it the correct way. I mean, in a vacuum, you could, in theory, have a 1B or 1A2 violation and not minimum contacts. I mean, I don't know specific facts where that would occur, but that could in theory occur, and that's why the Venetian Salami test is two-part.
Okay, we've taken you over your time.
Okay, thank you.
Thank you, Your Honors. Robert Shank for the Attorney General. As my friend aptly explained, this case is about the Florida court's power to vindicate an interest which this court said is one of the highest order in a free and civilized society. Justice Sasso, I want to briefly, before going to the statutory analysis, return to your question about the knowledge portion of this case. The fourth DCA, in its opinion, said that Race knew that Mitchell was in Florida at the time of the phone calls, and Mitchell has never disputed this on appeal. Now, I understand that there is a dispute in the RFAs below as it relates to one phone call, but my understanding is under Venetian Salami and a quadro, the proper way when an individual believes there's a factual dispute about jurisdiction is they have to submit an affidavit specifically disputing the facts that they believe aren't present and don't establish jurisdiction. And if you look at Mitchell's or Race's affidavit below, he never challenged that he didn't know that Mitchell was present in Florida. So we proceeded, at least in our briefing, that Mitchell in fact, or Race in fact knew that Mitchell was present in Florida. Now I understand that there is some skepticism turning to the statutory question about the court's decision in Mozo, which largely relied on federal case law interpreting
Counsel,
identical.
before you kind of get to the details, I have a big picture question. Mm-hmm. Can you explain what the state's response would be to kind of what the limit is for the legislature to regulate sort of behavior actions of people out of state that affect Floridian citizens? I mean, is there a limit? Is there a point at which we would say, no, there's a jurisdictional issue? Kind of where does the state view the line there?
Right. So obviously, there needs to be a constitutional hook to prevent the legislature from passing such an act. I do think that we're going to locate that in due process in the traditional analysis, either a minimum contacts or the effects test. I don't think that there's much of a distinction here between those two tests because they shake out the same when an individual either commits a tort in a state. We think that is sufficient, or they commit an act that an intentional act that they know will cause a negative harm in that state. And I think that that's really the limit on the state's power. There does have to be some type of interstate activity. There does need to be, I think, a genuine bona fide harm in the state. And I think the legislature has identified that harm as a harm to the privacy interests of people residing in the state of Florida. And that can be seen from not the fact that the legislature has separated out separate torts, separate crimes for the intentional interception of a communication and then the intentional use or disclosure. So even if the person never learns about the act of interception, the legislature has still said that's a harm. That's something that harms a person. The same way if a person trespassed across your property 2 weeks ago and you never learned about it until today, your property interests are still harmed, even though maybe you won't sue about it because you don't know.
So the state's position would be, for example, that if I were on a business trip in Argentina and I received a phone call that I didn't, that was recorded without my knowledge, I may not have a cause of action for or maybe I do have a cause of action for the invasion of my privacy. I'm a Florida resident, but I'm not in Florida. But upon disclosure of it, perhaps I could say, look, I'm long-term a Florida resident. Just because the communication was intercepted when I was overseas, the disclosure of it I do find to be tortious, and I'm going to seek redress for upon my return to Miami or wherever I go.
Obviously, that's something that we haven't briefed here. I think it's a different case, but I don't think that would be sufficient. At the very least, I don't think it would state a cause of action, because in order for a communication to be tortiously used or disclosed, I think it would have to first be unlawfully intercepted under the statute. So you'd have to, I think that would only occur if there's some nexus to the state of Florida, which I don't believe would happen there merely because you happen to be a resident.
This goes to Justice Sasso's question about the protective bubble and whether the legislature has enacted this sort of, privacy sphere that follows a Floridian wherever he or she purports to go, and what your remedies are. And what I guess I'm hearing the state say is we don't need to reach all of those questions. We, in this case, know enough to say that the protective bubble covers a Floridian sitting in Broward County, unless there's some affidavit from the other side saying, I didn't know he was in Broward County, I thought he was in Ohio, or something like that.
Yes, our position is that under the facts of this case, it is sufficient. I think it's a different case and may involve a deeper analysis if there were different thresholds of knowledge. And so we just haven't briefed that case, and we don't have a position on that. But again, we're not saying that there's this protective bubble that follows Floridian residents wherever they go in the country. We do think there has to be a nexus to the territory of Florida.
Can you tell me just, in terms of just the statute, whether you're talking about 48 or you're talking about the substantive non-recording statute, the knowledge of being in Florida isn't relevant. So walking through the due process analysis, which part of it is that relevant to?
I believe it's relevant to the minimum contacts inquiry. So there's three parts, right, arising out of or related to minimum contacts, and then traditional notions of fair play and substantial justice. I think it fits most clearly in the minimum contacts analysis because, again, as the Supreme Court said through Justice Thomas and Walden, the connection has to be between the defendant and the forum. And I think that, at least in this case, we're saying knowing that you're acting or causing effects in a forum is a sufficient contact.
That seems like the contact is what it is. It seems like maybe I think the fourth in the decision below seemed to think that it was more a matter of kind of fairness, that you don't know where the person is when you call, you don't know what you're in a state where it's legal.
Well, I do think that, to the extent that the defendants have raised the Campbell line of cases, I think that's a different type of due process limit on a state's ability to regulate certain extraterritorial conduct. But I take your point that there may be some fairness concerns. I just have a hard time locating it in the multi-factor analysis that the federal courts have set out when it analyzes the traditional notions of fair play and substantial justice. I suppose it could fit within the forum's interest in adjudicating a dispute. But in any event, wherever it's located, we do think that the fact that he knew he was acting in Florida is sufficient for these purposes.
And do you agree that it's not enough to show that there was a tort committed, quote unquote, in Florida? That we still have to do the separate, because it just seems to me that if you commit a tort in Florida, if we accept that premise, which I don't, but if I did, then I would just think that the due process part would be a slam dunk. I mean, what would be left to do?
I certainly agree with that notion. I guess we haven't teased out the limits of that theory. Certainly if a person tried to mail a bomb into a state and said, well, I didn't know where this zip code was located, I didn't know that the plaintiff was in Florida, we don't think that they would be able to get around personal jurisdiction simply by saying, I didn't know. But at least for purposes of this case, we've only briefed the issue, assuming that a person calling into the state of Florida knew that he was doing so. If there are no further questions, I will leave the rest of my time to my friend. Thank you.
Good morning, Justices. May it please the Court. James Toscano with the Lowndes Law Firm. This is my law partner, Rebecca Roden, representing the respondent, David Race. If the panel doesn't have any questions right off the bat, I'd like to...
Can I ask you a process question?
Yes, sir.
And I don't mean to be a fly in the ointment on this, but it seems like this was litigated in front of the trial judge on the premise that this whole thing was about the statute. And then the fourth, kind of on its own, did this due process thing, and then they certified a conflict in a situation where, I mean, you really have to strain to find a conflict, certainly in the sense of anybody doing any actual thinking about this. So what are we, I mean, we've had recent cases where when the DCA kind of went off on its own and decided something that wasn't presented properly to the trial court, we kind of said we're not going to sort of just take that and sort of build on that and rule on the issue. So why, to the extent that this case here, I guess in theory, is at least partly about the due process issue, why is that properly before us?
You're absolutely correct, Chief Justice Munoz. What happened is at the trial level, we were focused, because of a lot of the reasons that Mr. Steppen raised, we were focused on the long-arm statute prong of the analysis and whether a tort was committed in Florida. And then what the fourth DCA did was it basically put that issue to the side, decided the issue on minimum context, but then yet certified the question with respect to the long-arm statute, and then, you know, this esteemed court accepted jurisdiction. So I agree with you in that regard from a procedural perspective.
So what do we do then? Because you lost in the, you know, so do we just limit ourselves to the statute? I mean, what's the right thing for us to do at this point?
I'm not sure we should be here, because the fourth DCA decided on minimum context, and that was not the basis for the conflict. The conflict was with respect to the first prong of the long-arm statute. But here we are.
And our esteemed court's inscrutable footnote from that.
Yes,
a quadro or whatever.
And I think
not one of our finest moments.
Well, I'm not sure I agree with that, Chief Justice. I mean, the footnote is accurate. It says that a phone
it's
call,
kind of a non sequitur, but
right. It says the phone call into Florida may constitute a tort, and that's a factually true statement. I think this interception kind of took on a life of its own, and I think that the Coons Court addressed it probably better than anyone else. It said the cases we relied upon in Cook, and I understand that KOCH is pronounced Cook, did not address a jurisdictional issue, but rather involved statutory interpretation of the term interception, and that cites to State v. Mozo and U.S. v. Nelson, which I can get into and distinguish. And it goes on to say that the theory that a recording in a distant location is an interception inside Florida may be appropriate for some legal purposes, but we conclude it is insufficient standing alone to support a claim that a person in a distant state or country committed a tortious act within Florida.
But what support do you have, state or federal, for the proposition that the tort occurs at the locus of the recording? It seems to me like there's precedent, state and federal, for two propositions. One, that it occurs at the place of oral initiation, A-U-R-A-L, oral initiation, first place it is heard. And then there's the federal precedent, the listening post stuff, about how it occurs simultaneously from a metaphysical perspective in both places. There doesn't seem to be any case law supporting the proposition you seem to be arguing for, which is that the relevant act occurs where someone pushes the record button, and it seems to me like that stands for good reason. That stands to reason because there's so many, you know, imponderables that then flow from that. Is it from the cell phone tower? Is it from the satellite to which the cell phone tower beams the communication? So what I guess my question is, what's your best case for the proposition that the interception occurred in Ohio?
I don't think there is one, Your Honor. I don't. I think the case law does say that the interception, as far as the statutory interpretation, which is what the Kuntz court was dealing with, is in Florida, where the communication was first uttered. But I think the distinction is it's from the privacy perspective. If you look at, in the Nelson case, the dispute was whether the wiretap order, which was issued in one district, applied because the state agents who were, the federal agents who were listening in were in a county outside of the district. And so that's how that was the genesis of how interception was originally defined under Nelson. And Mozo dealt with a cordless phone. But as Chief Justice Munoz pointed out earlier, the distinction is, in those cases, the interceptor is a third party. So there's a right of privacy, there's a communication between a Florida, and both of those cases, they're both criminal cases, they only deal with Florida residents, they both involve the statutory interpretation of interception, and neither one of them deals with jurisdiction. But from a privacy perspective, if you've got two parties having a private conversation, one of them's a Florida resident in his or her home, there is a reasonable expectation that there's not going to be some third party, there's not, the state big brother is not going to be listening in on that conversation. But if there's a two-party conversation and one of the participants is the interceptor, then I don't think that there's a reasonable expectation that the person who is hearing the communications won't then relay that to some other third person.
Well, but there is, if you're in Florida, when you're speaking on the telephone to someone wherever, there is a reasonable expectation that you're not going to be recorded unless you've given permission. Right? I mean, that's what the law is about. I mean,
well, I guess if there's a reasonable expectation that that's the law in every other state.
Reasonable expectation that, you know, we assume that the people know what their rights are under the law. I mean, that's part of what we would assume. And that's, it just seems that there is that expectation that, you know, when I get on the phone and I'm talking to somebody, I assume, unless they've told me, they're not recording me. Now, not that I would care.
Well, and that's a good point.
But some people might care. And you've got a right to care because you've got a right under Florida law not to be recorded surreptitiously.
And I absolutely agree if that's two Florida residents having the conversation. But Florida is one of only 11 states that has all-party consent. I mean, I don't think it's reasonable to assume that...
Well, but that doesn't make us chopped liver. I mean...
No, I think obviously there is a right to ensure the privacy protection of Florida residents. And Your Honor just said it. You wouldn't care. It's an accurate transcription of what you said.
Well, I said I might not care.
You might not care.
Some people might.
But the statute...
I mean, I can understand that it's not unreasonable to think that there's some sort of violation of recording a private conversation. That you, when there's a right to not have it recorded without being told that it's being recorded.
Well, the right is a statutory right, and the statute doesn't require any showing of damage. And so if you're going to impose this statutory requirement...
Damage to your dignity.
In some instances, I would rather have an accurate recording of what I said rather than have the recipient you know, not accurately relay it to a third party.
Can I ask, so if we're trying to sort of do this from a kind of textual perspective, and if you read the text of 48 whatever, and you think that there isn't really a sort of clear reading from a textual perspective that would tell you where, you know, where the tortious act is occurring, or at least where the defendant's part of the tortious act is occurring, where do we go to find sort of the kind of external, whether it's canons or principles or whatever, to kind of inform how we should use our judgment to figure out that tie? Because it seems like in Altenburn talks about strict construction, and it seems like he's kind of trying to smuggle in some of the due process stuff into the statutory analysis. So like, what would you, if we don't think that it's just a matter of whipping out the dictionary,
right,
then how do we resolve that?
I think, and there's lots of overlap, right? I think there's overlap both between the two prongs, and then in the second prong there's overlaps between the effects test, minimum context, and notions of fair play and substantial justice. But I think the way to look at it is Mr. Race reaching into Florida to commit a tort? Or is he in Ohio with the app on his phone doing the recording? And I think in this case, from a constitutional due process perspective, Mr. Race isn't reaching into Florida, but Florida is reaching out into Ohio and administering a statute that is effectively punitive.
I'm not so sure about the reaching in, reaching out. Let me ask you the same question that I asked your friend at the outset about 481936. Do you concede that the operative complaint alleges the causation of an injury to person or property within this state? Because it seems to me like if you do, game, set, match. I mean, like, we're arguing about whether or not a tortious act was committed in the state. And let's just put that aside for a minute. If the complaint alleges that injury was caused to a person within this state by an act or omission by the defendant outside the state, then all of these metaphysics go away.
To some extent, I would agree with that. I think, and A, it doesn't allege that, but if it did, and taking that as true, that would be a tort committed in the state, correct? And I think
well, no, but you see, there's a reason the statute splits the two.
Right.
The statute says a tort will get you there.
Yep.
And then the statute says something else that must be different than a tort, or else it would be surplusage. And what it says is causing injury. Like, you know, I'm standing on the Georgia side of the Florida-Georgia line, and I throw a rock across the line. I may or may not, like, have caused a tort. Maybe I was throwing the rock to my friend and I missed and I hit somebody instead. But I committed an act that caused injury in the state of Florida.
There you go, right there. There is no injury in the state of Florida.
Well, no, but here the complaint alleges an injury in the state of Florida.
Understood.
So it makes it a statutory no-brainer, but you're still left with the due process.
Understood.
Right.
Understood.
So is that? But I guess is the chief right? Is your refuge due process because basically the statute? Yes, this could have been the operative complaint could have been amended to state 6 instead of 2. But
under that circumstance, I would agree with you that my refuge is the second prong of the analysis. Yes, because we're taking the allegation as true, obviously, at the motion to dismiss stage. I would have to concede that, Justice Curiel.
Okay.
So are you aware of any due process case where it was accepted that the tort occurred in the state, and then when you get to the sort of minimum contacts and whatever, all that you would still say that it violates due process for that to be litigated in the state where the tort occurred?
I mean, the case law is clear about the 2 prongs, right? But I think that's kind of what the France court did.
I mean,
I think that's kind of what the court in France v. France did. They found that the tort was committed in the state, and then they just...
Because I just keep coming back to the sense that you either win on your statutory thing and then the due process goes away, or if you lose on the statute, I don't see how you could lose on the statute but then say, oh, even though the tort was committed in Florida, we can't litigate the case here. That doesn't seem right.
And, Judge, you took the words out of my mouth. That's what I said at the hearing in front of the trial court, and that's why it was a rifle shot argument with respect to whether the tort was committed in Florida, given the allegations of the complaint. We did not focus at the hearing at the trial court on minimum contacts. To Justice Sasso's point, we didn't have an evidentiary hearing. We were really just focused.
So when we're dealing with this, we really are limited to the statutory issue. I mean, to go off into the due process, we're talking about things that really the parties here did not litigate.
I agree, and to Chief Justice Muniz's point, that the decision of the 4th DCA was based on the second prong, minimum contacts. And so it certified the question with respect to the first prong. But that wasn't the basis for the decision.
So you say discharge jurisdiction. That's really what you want us to do.
We're here. We briefed jurisdiction.
Respondents always say that.
We briefed jurisdiction. I'm happy to be here. I wanted to be here, so I wanted the court to accept jurisdiction. But I struggled with the issue that Chief Justice Muniz raised with respect to what is the conflict in terms of how the case was decided by the 4th.
Well, the reality is there doesn't actually have to be a conflict if they certified a conflict. We have jurisdiction.
Well,
I'm not arguing jurisdiction. There might be a prudential judgment about whether we would exercise it or not, but we that no one questions that we have jurisdiction of this case.
I'm not arguing there's no jurisdiction. I was responding to questions. At no point did I ever take the position that this court does not have jurisdiction. That's not my intent.
What you would take the discharge?
Are you offering? Happily.
To the extent there's a duty owed not to record calls, do you think that in terms of evaluating whether a tort occurred in Florida, we should focus on whether there was a duty owed in Florida? Or is it the obligation not to record and we focus on Ohio? Or do we focus on duty is owed not to record Floridians' phone calls in Florida and we focus on that for the purposes of determining where a tort occurred?
Well, you know, I can't argue with how interpretation has been defined in the case law. And interception, I'm sorry, how interception has been defined. And an interception is a violation of the statute. And so that's why I quoted the Kuntz court in distinguishing the statutory interpretation of interception versus the jurisdictional analysis, which I think is more appropriate. And that obviously dovetails into the privacy concerns. But to answer the question, I think it should be limited to a Florida resident speaking with a Florida resident, and under the circumstance of the interceptor being a third party. I'm not sure how it translates into a two-party conversation when the recipient of the communication, I mean, could take extensive notes, could take accurate notes, could, to the extent that the recipient knew shorthand and was able to transcribe accurately the conversation. If the recipient then relayed that, there would be no violation of the statute and there would be no harm.
So this is a criminal statute, and we have a section 910.005 that talks about state criminal jurisdiction in general, and it says a person is subject to prosecution in this state for an offense that he or she commits while either within or outside the state, if the offense is committed wholly or partly within the state. And then it says an offense is committed partly within the state if either the conduct that is an element of the offense or the result that is an element occurs within the state. So I'm wondering, should that inform our analysis at all?
I think that would run afoul of fair play and substantial justice. I mean, if you've got someone sitting in
just on the statutory part.
On the statutory
as
part.
Far as whether because I think, I mean, it seems to me the whole case hinges on whether we really think the tort occurred in Florida or not in Florida.
Well, under that reading and under the case law, I think the conclusion is the interception, which, I mean, the problem is it's not really a tort. It's a statutory violation.
Violation. Well, but tortious, I mean, we're assuming.
A tort is a civil harm.
That's where you and I differ. I mean, there's no harm.
It's a violation of a legally protected interest.
Absolutely.
That's a tort.
And you accept that it's tortious, that a violation of this statute, if there was no dispute that it was violated, you would consider that tortious activity or conduct or whatever the jurisdictional.
Understood.
Okay.
Yes. If there are no further questions, I'll yield the rest of my time.
Thank you.
Thank you.
Thank you, Your Honors. I will try to make this very short. I do agree with, I guess, what appears to be a consensus that this case can be decided on whether or not a tortious act was committed in Florida under the long-arm statute. And at the end of the day, it was. I mean, intercept has been determined by the case law, particularly Mozo, but also the other DCAs, as occurring where my client spoke, which was undisputably in Florida.
And tell me why textually, put the case law aside, and I'm not saying that we should or would do that, but tell me why textually, how am I supposed to know that that's where the interception occurs in the context of the two people who are the intended participants in the call?
Because you can't have an oral communication as defined by the statute unless it's uttered by a person. And obviously a phone call is an oral communication, as Koch v. Kimball recognized.
But is an interception the key word?
Yes, it is. And interception, I will agree that interception doesn't state in the statute where interception occurs, whether it.
Okay, so that was my question. So what if I'm going to find the answer in the statute rather than in the case law, how am I supposed to know where the interception occurs?
Well, then you look to the other definitions, particularly oral communication uttered by a person. How do you utter something where you're not
Yeah,
present?
but that doesn't tell me where it's intercepted. I
Well,
mean,
it does in this sense because, I mean,
first of all, I mean, it's not a natural use of language to refer to recording a call that I'm on and that I'm intended to be on as an interception.
That's
first of
correct.
all, right? So this is all kind of a construct. So textually, is there anything that tells me where the interception occurs?
oral communication, also the definition of oral transfer, that's A-U-R-A-L. That's in there.
That's hearing.
That's hearing, yes, but it means a transfer containing the human voice at any point between and including the point of origin and the point of reception.
Let me take a shot at this. I think we've been very fixated on the interception or the recording as if it happened in Ohio. But the truth of the matter is that what is recorded, this voice communication between these two phones, is just as recorded in Florida as it is in Ohio, right? Like, the technology is recording that oral thing that is being uttered in Florida. And to me, there is no other point at which it makes sense to draw the line other than the first place where it is heard. There's no logically satisfactory alternative to where something is first heard, because what is recorded is in fact that line of communication. It's not like it's being recorded by a tape machine in Ohio. It's that whole communication that's being recorded. This is me talking. This isn't necessarily you. But is that what you're arguing, that essentially the recording happened in Florida because that's where the communication was complete? Like, without Florida, there is no recording.
Yes, I think that sums it up.
But why isn't the right question what the defendant is doing? I mean, it seems like there's this sort of like, how do we sort of metaphysically view the conversation and where it's happening and whatever. But it seems like the whole point of this area of the law is to focus on what the defendant is doing. And the defendant is making the decision to record, he's hitting the button. None of us know like where things are bouncing off towers and whatever, but in terms of everything that the defendant is aware of, it's all happening in Ohio. In terms of the recording part of it, not the conversation part.
Well, you mean the physical act of the cell phone app that he had on his phone that recorded every phone call? Yes, that was in Ohio according to what he says. So his phone was in Ohio. But the defendant, at least in this case, he knew my client was a Florida resident. And, I mean, he's recording calls of them. He recorded calls of other Florida residents. So if you want to focus on what the defendant knew and did, I mean, he had a pretty good idea. If he didn't know outright, he had a pretty darn good idea. He was talking to a Florida resident. It's a 954 area code. My client was fairly well known to be a Florida resident in the context of the gaming community. So for him to say that he didn't have any idea that Mr. Mitchell was a Florida resident is just wrong, and frankly, he's not even taking that position.
Okay, thank you. You can have 30 seconds to finish up.
Just for all the foregoing reasons, Your Honor, we ask that you quash the decision of the 4th District and remain back to the trial court for further proceedings. And also, I know this didn't really come up in oral argument, but there was a secondary issue, which was appellate attorney's fees. The statute 934.10 has a one-way street for a prevailing plaintiff. We move for attorney's fees.
So this is rebuttal.
Oh, yeah, okay. So that's the gist of it. With that, I'll sit down.
Okay, thank you. We'll be in recess for 10 minutes.
All rise. This honorable court is now in recess.
Still alive, so that's good. Okay, Maura, ready to raise your right hand? Okay. I do solemnly swear that I will support,
I do solemnly swear that I will support,
protect, and defend the Constitution
protect and defend the Constitution
and government of the United States
and government of the United States
and the state of Florida,
and the state of Florida,
that I am duly qualified to hold office
that I am duly qualified to hold office
under the Constitution of the state,
under the Constitution of the state,
and I will well and faithfully perform
and I will well and faithfully perform
the duties of Deputy Clerk
the duties of Deputy Clerk
of the Florida Supreme Court,
of the Florida Supreme Court,
in which I am now about to enter.
of which I am now about to enter.
So help me God.
So help me God.
All right. Welcome. You're official.
Thank you very much.
Thank you, guys.
Oh no, how do I get the pen open?
Oh, wait, I didn't know you were left-handed.
I am.
No, forget it. Can't do it. All right.
Here we go. You're a lot better at that. Get rid of her now. Like her.
Florida Supreme Court is now in session. Please be seated.
Thank you. We'll now take up case number 2022-1553, Cox versus State of Florida.
May it please the court, counsel. Robert Pierce on behalf of Mr. Cox, we requested 5 minutes of rebuttal time. Well, good morning. This capital appeal stems from Mr. Cox's conviction in 1998 for the murder of a fellow inmate at Lake Correctional Institution, and his most recent penalty phase in 2022 after being granted Hearst relief in 2017. Now, we've raised 7 points in the initial brief, but for the purposes of today's discussion, I'll be focusing just on the first 3. The first 2 of these are very similar. They both stem from the court's sentencing order and involve the court's rejection of a total of 3 non-statutory mitigating factors, 1 for not being proven, and 2 for being, in the court's view, not mitigating on the facts of the case. For these 2 points, we're seeking the relatively limited remedy of a remand for the court to consider what we contend are the erroneously rejected mitigating factors and to conduct a reweighing accordingly. And for point 3, which involves unobjected to comments in closing argument, we're seeking the more substantial remedy of a remand for a new penalty phase. Regarding point 1, which dealt with the mitigator relating to Mr. Cox's dementia, the court, despite the state conceding that this was proven in their sentencing memo below, and despite the court acknowledging the expert testimony that the defendant has dementia, nevertheless rejected it as unproven. And it did so under the rationale that, quote, there is no evidence that Mr. Cox suffers from the early signs of progressive dementia. But there's 2 problems with this. First, the mitigator itself didn't limit itself to progressive dementia. So the question of whether it was static or progressive dementia isn't dispositive of whether this mitigator was actually proven. And second of all, there was actually evidence of progressive dementia. Dr. Rubino testified that he could, progressive dementia, by the way, is just something like Alzheimer's disease, whereas static is something that is caused by an event, like a traumatic brain injury. Dr. Rubino testified...
Doesn't the mitigator suggest progressive dementia, though, when it says early signs of dementia, versus a static dementia that seems to be more limited in time, and then you're looking at the effects from that? Go ahead.
My read of the mitigator is that the early signs of dementia is just referring to his age, that because the testimony was establishing that this condition was occurring, the atrophy in his brain resulted in him being older, or results that indicated an older gentleman. So like someone who has the same results someone should be expected to do better on this even at age 80 than he's doing it at age 59. So I've read that as relating to the age, but even in the event that the court reads it that way, it still doesn't fix the problem that there was evidence of progressive dementia, because as Dr. Rubino testified, his testing puts him in a range where he could really have Alzheimer's disease. Quoting, he's definitely in a range where he could also be suffering from early Alzheimer's disease. He has significant risk factors for Alzheimer's disease. His testing has gotten worse over the years, and his testing puts into a range where if he were a Parkinson's patient, he would not be allowed to say that he could have consent to surgery.
And I've looked at all that testimony, but if you look at it all in context, it looks like he's equivocal about it. I mean, and I think that's what the trial court found, isn't it?
Respectfully, I'd have to disagree, Your Honor. I think the testimony...
You don't think the trial court found that?
That the court, that he found
that it was equivocal? Whatever.
Oh, yes. No, that was exactly his rationale.
But again, part of this is, I understand there are different ways to look at these things, but the trial court is the trial court, and unless it's unreasonable and there's not evidence to support what the trial court does, we go with the trial court.
I agree.
And this, what you had just said about the way this was pled, not indicating that it was about progressive dementia, I hear you, but it seems like to me the opposite reading of that is more persuasive. I just don't understand why it would be phrased the way it was if it was talking about anything other than. Now, I heard what you said, but it seems to me eminently reasonable for the trial court to interpret the way it was pled the way the trial court did interpret it. But so tell me why I'm wrong.
Well, no, I won't. I think that is a reasonable interpretation of that language. I'm not going to say that the trial court was unreasonable for interpreting it that way. However, I don't think that fixes the problem that there was evidence of progressive dementia, because his testing, as Dr. Rubino testified, puts him in the range where he could also be suffering from Alzheimer's disease. So the court's rationale for rejecting this was that there's no evidence of progressive dementia, but in fact there was. And so even if we disregard.
Did I hear you say the word could?
Pardon?
Did I hear you say the word could in what you just said? He could be suffering from Alzheimer's?
Yes, Your Honor. The testing range.
Could doesn't cut it. I mean, you have to prove these mitigators.
Well, if we're going off of a reasonable reading of the language of the submitted mitigator, it's early signs of dementia, which I believe the signs of dementia kind of lessen that strict threshold that you're suggesting. But
so is your argument, and I want to just make sure that we have the argument right, that the trial court abused its discretion in rejecting it versus failing to address it? Because the initial brief talks about it as a failure to address, which requires a remand to address it. And I think what you're arguing today is the trial court abused its discretion in rejecting the evidence.
The argument specifically is that the court did not have a rational basis for rejecting the unrebutted expert testimony establishing dementia.
Okay.
So it's
so that's not really a failure to address argument.
No, and this is what distinguishes it. This will come up in the second point relating to Gill, but it's not about a failure to address. It's about the kind of the procedural posture of this evidence before the court and whether or not its decision to find it either unproven or in the later points not mitigating on the facts of the case was rational. So I'll move on to point 2, which deals with the mitigator relating to Mr. Cox's impulse control. Now, in rejecting this mitigator, the court acknowledged that Mr. Cox has suffered from impulse control issues throughout his life, but still concluded that it was not mitigating on the facts of this case because the actions leading up to the murder, in the court's view, show that he could control his impulses. But there's 2 problems with this rationale. The first is that it's treating this condition, this diminished capacity for impulse control, as though it's an all or nothing thing, as though it's a condition that's either acting up on a certain day or it's not. But even in the court's sentencing order, it acknowledges that this is a diminished capacity thing. This is a relative capacity to a normal person to control their impulses. The court, as I said, acknowledges this in their sentencing order, and this is what differentiates this case from Gill, which is what the state relies on to support the court's rejection of this. Because in Gill, we have almost exactly the same thing, where the court finds that a very similar set of evidence establishing a brain condition that causes diminished capacity for impulse control. But in Gill, and unlike the instant case, the court actually gave that some weight. And so I think it kind of shows the problem here, because while the court would have been free to assign it some non-zero amount of weight, there's not a rational basis to reject it as not mitigating at all.
Well, it was the trial court accepted testimony of an expert in reaching the conclusion, right? Dr. Lazaro?
Well, I think the state's position, in the sentencing order, he did not rely on that testimony. And I think the state pointed this out in their answer brief. So the court's rationale was based purely on his view of the defendant's ability, whether he could control his impulses that day or not. I don't think it was based off of Dr. Lazaro's testimony, but even if it was, the problem with Dr. Lazaro's testimony is that it doesn't actually address the root of this mitigator, because the root of it is the damage to the portions of Mr. Cox's brain that affect impulse control and the resulting diminished capacity to control those impulses from that damage. So it's not about whether or not whether the murder, as Dr. Lazaro testified, whether or not it was an impulsive murder, whether or not you could categorize it as something impulsive. The mitigator is about his relative inability to a normal person to control those impulses. And so again, the court was free to assign it a lesser amount of weight, but what it couldn't do is reject it as not mitigating at all, because again, this is like a relative diminished capacity.
Counsel, why isn't, let's assume that we accept your premise, why isn't it just harmless? Because it seems like the court considered 19 other mitigators, right, some of which overlapped with that dementia diagnosis, some sort of cognitive issues. So why isn't it just harmless?
Well, I think that's a good question. I want to distinguish 2 things. That one, that portion of what else he considered for dementia is not related to this point about impulse control. And importantly, in the sentencing order, the only mention of impulse control is on this at this point, outside of the statutory mitigators, which he rejected. The impulse control is only mentioned in addressing this specific non-statutory mitigator. The question of why this isn't harmless, while it's the state's burden to prove this, I think there's 3 very good reasons why this case, why the error can't be considered harmless. First, it's the heart of the defense. This was both the defenses, the heart of the defense for both mitigation and in challenging CCP, which the jury rejected. It goes two of the most important things before the sentencer, which is the moral blameworthiness for the offense and the prior violent felony aggravator, because this mitigator was submitted as being ameliorative of both the offense itself and the prior violent felony aggravator. And it's clear from the sentencing order, or at least from the rationale in the sentencing order, that the reason for rejecting it is based purely on the offense. So the court did not address the whether it would be ameliorative of the prior violent felony, which is the weightiest of the two aggravators in front of it. And so because it's going to the central question before the sentencer in any capital case about the moral blameworthiness for the offense, because it's also going to the weightiest aggravator there, and finally because in the defense's view, it's our position that this presents at least a case where the decision of death could not have easily been reached, given, as I was mentioning, the lack of CCP and EHAC, and the fact that there's the two remaining aggravators that were found overlap to a decent degree, given that he was in prison for his prior violent felony, or he was in prison because of his prior violent felony. Because of that, I think those three things combine to meet the relatively low threshold for harmless error, which is just a reasonable possibility that of a lesser sentence if the court were to consider this mitigator.
It seems hard, though, to see how you could say that that a reasonable judge could give it slight or little weight, but then it seems like it would be just a completely sort of empty, kind of formalistic exercise for us to say, you have to deem this a mitigator, but if you want to say it's obviously someone who thought it wasn't mitigating at all is not going to turn around and give it, great weight. They're just going to stick a different, a slight or little label on it, and then we're going to end up in the same place.
Well, I would hope that they wouldn't just go back and rubber stamp their previous decision without reconsidering the aggravators and mitigating circumstances.
And I don't mean that in a pejorative sense, but if they believe that it's just not mitigating, but we say, well, you have to deem it at least somewhat mitigating, then if you assume that, it's the same thought process by a person who did their job and was thoughtful and whatever, it seems hard to believe they would give it anything other than slight weight.
Well, I don't think that, I think the problem with this is, and let me clarify one point earlier. When I said the court could have assigned it some amount of weight but couldn't have, a very little amount of weight, but couldn't have assigned it zero, I wasn't suggesting that this is a mitigator that's worthy of little weight. In my view, it's worthy of a significant amount of weight. And I think the reason why the reasonable likelihood of a lesser sentence exists is because the court did not consider, appears to not have fully considered the ameliorative nature of it, specifically because he's rejecting it as he's not appreciating the relative nature of it, despite acknowledging it in the sentencing order, and I think equally as importantly, never addressed the ameliorative nature of it related to the most weighty aggravator before it. So because from our perspective in this posture, we're looking and saying, well, there is at least a reasonable likelihood. It appears that the court did not consider this based on the sentencing order, based on the rationale we were given. And so the question is just, is this sufficient enough to create that reasonable likelihood of a lesser sentence? And I think its locus with the central question before the sentencer clears that bar, I think, by a significant margin, because we have not only just the close case, but the fact that this is going to the question before the sentencer on such an important decision about whether to impose the death penalty or not. Lastly, I want to close just by making a couple points regarding the fundamental error in closing arguments. Now, the standard for this is whether or not the comments were so prejudicial as to taint the jury's recommended sentence. Obviously, there weren't any objections to these below. The state has commendably conceded that the comments relating to justice were improper, but have contested the other two types of errors that we've challenged. One of them I'll refer to as just the easy way out comments. They point out that similar comments were held improper by Irvin, but in Brady, and I think they're correctly pointing out that in Brady, this court rejected similar easy way out comments because the prosecutor did not also accompany them by misadvising the jury regarding a duty to come back with a sentence of death. And it's true that the prosecutor did not do that here. That's not what I'm challenging, but I think it's important to distinguish that he did tie those easy way out comments to a different type of improper comment, which was justice for the victim. And so,
but when we look at both of these comments, they're both kind of, he makes them at the beginning of the closing argument, very long closing argument, and it ends with this emphasis on the law and the facts, and that this life sentence wasn't sufficient to deter him in the past, so why would it be sufficient to deter him now? When you have these kind of isolated comments at the beginning, why, if we're looking at fundamental error, do we place the significance of that over the entirety of the closing that occurred after?
Well, I think it's clear that that fundamental error is clearly viewed, you clearly view the closing arguments as a whole, and I see I'm eating into my rebuttal time. So no, I think you have to look at closing arguments as a whole, and see everything in context. The problem with these particular errors are that they are using the weight of the state to pressure, or at least invite the jury to reach their ultimate decision based on a reason other than weighing the aggravating factors against the mitigating factors. And so that's why we believe it amounts to fundamental error.
Isn't typically when we reverse on fundamental error in a closing argument situation, it kind of pervades the closing argument, and it's the sense that the jury is left with. Like, it's not this kind of isolated statement at the beginning. It's really runs throughout, and it is the emphasis of the closing argument.
Typically, yes, I believe the trend for these cases has been to have a collection of a lot of improper closing arguments, and then tying them all together and saying these cumulatively amount to fundamental error. I think the problem is that effectively this gives the state a free pass to make these improper arguments regarding justice for the victim that have been held improper since the first Reagan administration.
Well, if it's objected, it becomes a different analysis if it's objected to.
It certainly becomes harmless error at that point. I think the problem here is just the indelible nature of the prejudice from these comments, and inviting the jury on such an important decision to make a decision about the death penalty for reasons other than the aggravators and the mitigators. So with that,
can I ask you a question about the commendable concession?
Yes.
Isn't this, I know that our court has said without any kind of reasoning backing it up, they've questioned these justice comments, and they usually talk about the impropriety in terms of, improperly trying to elicit sympathy for the victims and everything, but just without kind of surrounding sort of emotional appeals. I don't know why talking about justice would be improper when it seems like this whole exercise is basically about justice.
My first thought is the language from Cardona v. State, where it talks about how the cloak of the state's authority, when a prosecutor is standing there with the cloak of the state's authority, it gives them the ability with a minimal amount of words to create a significant prejudice and impact on the jury. And I think by making these appeals to anything outside of the central question, the only question before the jury, which is relating to the aggravators and mitigators, I think once we stray from that and start bringing in concepts like justice, especially
but isn't the whole point? I mean, when the defendant is up there, trying to establish mitigators and arguing it, aren't they basically kind of saying, given this kind of mix of circumstances, it would be unjust to execute my client or me? I mean, isn't that really what this is all for?
Well, I don't think they're arguing for justice in these cases. I think they're arguing for mercy, and I think they're fundamentally different concepts. And I don't think those, similar comments from the defense, don't carry with them the same kind of prejudice that, again, speaking with the state's authority to a lay jury about how justice is impacting their decision. I think it invites it's the kind of impropriety that shouldn't be guiding cases, especially in a death case. So with that, I'll reserve the remainder of my time.
May it please the court, Assistant Attorney General Stephen Ake on behalf of the state of Florida. As to the first issue, I would submit that the court properly denied the non-statutory mitigator that appellant suffers from the early signs of dementia. Dr. Rubino was asked on, I believe it's page 767 of the record, for his diagnosis in this case, and he started a laundry list of the various things that he diagnosed the appellant with, and dementia was not listed as one of those. The defense attorney then questioned him as to his neurocognitive disorder, if dementia would be included in that, and he said it probably could be. Again, not equivocal diagnosis of that condition. He testified, Dr. Rubino, that the results of the Montreal cognitive assessment test that he gave the appellant put him in the range of it. Again, he did not diagnose him. He just said his test scores were consistent with that. Based on that evidence, I believe the trial judge acted within his discretion in rejecting that non-statutory mitigator based on that testimony that it was not established by the greater weight of the evidence. But even if this court were to find that the trial judge erred, the court did find numerous other non-statutory mitigators related to appellant's cognitive functioning that I would submit would make any error harmless, because he found brain damage, he found deficits in his executive control, numerous ones related to his alcohol and drug use and its effects on his brain, brain injuries and all that. I don't believe that a medical diagnosis of dementia or even progressive dementia, which again Dr. Rubino said he couldn't diagnose him with, I don't think that would have changed the sentencing calculus in this case whatsoever, and the judge still would have sentenced him to death even if he had found that. So I don't think there's any error in that first issue. On the second complaint that appellant has about the mitigation, which deals with the second one, which is the
impulse control.
Excuse me?
Impulse control.
Yeah, the impulse control thing. Yeah, I was thinking it was the sine qua non thing, but no, the impulse control. What happened here is the trial judge based his rejection of this mitigator. He found that he had established that he had impulse controls throughout his life, but given the facts of this case and Dr. Lazaro's testimony that this was not an impulsive murder, the trial judge was justified in finding or in rejecting that mitigation. This court has upheld other instances where courts have found that a rejection of impulse control is proper given the facts of the murder. And in this case, we have the defendant planning it out a day in advance, announcing his intention to the entire prison pod that he was housed with, and saying that he's going to give a reward. He then gets information about who may have broken into his locker and stolen his money, and he basically orders a shank from another prisoner, conceals that, waits till the next day at lunchtime when he realizes that there will be less correctional officers in the prison yard while they're at the cafeteria, and he calls over the victim and begins to pummel him. Now, Alan Cox outweighed the victim in this case by about 100 pounds, and by all the accounts, he did this beating in front of numerous inmates and had the victim in the fetal position begging for help, and he said, "That's not good enough, then he reaches into his pocket and stabs him 3 times. That 24-hour or thereabout 24-hour passage of time shows that this is not an impulsive murder, and the trial court properly rejected that mitigation. Again, even if this court were to find that it was error, I would submit that it would be harmless, because as Chief Justice pointed out, you would, I guess, remand it back to the trial judge for him to find and weigh that, and I'm sure he would not give it more than very little weight or slight weight or what have you, but that's not going to change his ultimate sentence in this case, given the strong aggravation that was present in this case in the mitigation. As to the other issue that counsel talked about were the closing arguments by the prosecutor that were not objected to. Obviously, it has to rise to fundamental error, and the state would submit that really what we're boiling down to, he raises 2 little paragraphs that the prosecutor discussed, and the first one, I don't see anything wrong with that comment whatsoever. Really, the only issue is the prosecutor saying that, is this justice for the victim? And that's a very innocuous single comment that he made early on in his closing argument. It's not near as egregious as a number of cases that this court has discussed that comment in. I don't think it rises to the level of fundamental error for sure. There's no way that the jury, that single comment is going to affect the jury's recommendation in this case. So the state would submit that appellant has not shown any error in this case, and that this court should affirm the sentence. If there are no further questions, I'll rely on my brief for the remaining issues. Thank you.
Thank you.
Just one final point regarding the harm in point 2. The court's rejection of this is not mitigating. The problem with it is that it ends up running afoul of the Eddings and Lockett, of the court not listening to the mitigation. And I think the question simply, if this court agrees that the impulse control mitigator was, that it was error to reject it as non-mitigating, is just simply whether this mitigator, which again goes to the heart of the defense, it goes to the question of both.
Does it go any more to the heart of the defense than the other mitigators that the court did in fact find that are sort of sung in the same key?
I wouldn't say they're in the same key, just because, again, the only
they go to his mental status, they go to his brain injury, for example, right? Like, that's just, you know, the court finds it and gives it the weight it does. Help me understand what I'm missing, because it seems to me like that is before the court has acknowledged it, and if it finds that this other mitigator isn't established, it still has this other basis that was weighed by the court in determining its ultimate sentence.
I think the impulse control mitigator is fundamentally different from the others, and the court's reasoning for rejecting it, it rests on the idea that it's an all or nothing thing, and it seems clear from that rationale that the court did not appreciate the nature of this mitigator, given that it's affecting his diminished capacity. It's not an all or nothing thing.
But the brain injury is the same. I guess that I'm not hearing really an answer to my question.
I apologize. The injury here is, or the mitigator here is going to the injury that is affecting the portion of his brain that is affecting his ability to control his impulses. He has a diminished capacity relative to a normal person to control those impulses, and that the mitigator was submitted as being ameliorative of both his inability to control his impulses and commit the offense, and of his prior violent felony offenses. So even if this court rejects it as being unrelated to the current offense, it wouldn't fix the problem in the sentencing order of the court not considering the ameliorative nature of it related to the weightiest aggravator before it, which is the prior violent felony. So, with that, I request this court reverse for either reconsideration of the aggravators and mitigators or remand for any penalty phase. Thank you.
Thank you very much. We're adjourned.
All right.